The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Am I live here? All right. Welcome to the Iowa Supreme Court. This is a real case. It's not a moot court. We appreciate very much coming out in the evening and showing your support for court action as well as your own community. We've enjoyed getting to know a little bit more about Bondurant. I also want to welcome, I believe there is a Boy Scout Troop 178. Raise your hand here for 178. We see you, barely. We see you. Thank you for being here. I thought perhaps I would brag about one of my colleagues being an Eagle Scout, but there are none up here. However, I, until a senior in high school, sold Girl Scout cookies, so I think I win the award tonight. So welcome. Very important club and committee that you are involved in as a youth. Tonight we are here for oral argument of one case. The case is called State of Iowa versus Adam Rhodes. And it looks to me like the parties are ready. Okay, Mr. DeVolder, you may begin.
May it please the court, counsel. I represent Adam Rhodes, who's appealing on direct appeal his criminal conviction of being a felon in possession of a firearm under the Iowa Weapons Statute in Chapter 725.26. The charges arose from Mr. Rhodes harvesting of deer in the fall of 2021 using a Thompson Center Impact 50 caliber muzzleloader to take that deer. On appeal, it's our contention that the Thompson Center Impact muzzleloader is a replica of an antique firearm as defined in subsection 25 of the Weapons Statute, Iowa Code Chapter 724. And as such does not constitute a firearm within the criminal statute, section 26, which is right next to this. And we say it for these reasons. As set forth in the dismissal motions of this charge, the Thompson Center Impact muzzleloader at issue in this case could not fire or even be made to fire, either ring fire or center fire fixed ammunition. Its firing mechanism was of the early 19th century vintage, meaning it would have a hammer that would hit a percussion cap, would send a spark down the anvil where the percussion cap was located, to fire the weapon.
I want to ask you a question that's a little more broad. You're saying it's an antique firearm. If this court would determine that it is just plain a firearm, has that taken all the wind out of your sails?
I'm sorry?
Has that taken all of the wind out of your sails if the court would determine it is a firearm?
Well, if the court were to determine it is not a replica of an antique firearm, yes. I guess in direct answer to your question, if I understand it, Your Honor, the code does not define a replica of an antique firearm the same as simply a firearm. They're different terms.
But the manual and some of the purchase, the receipt and things like that, didn't they just refer to it as a firearm? There was never the word replica in any of that documentation, was there?
I'm sorry, this is a large auditorium. I'm having a little trouble hearing. Could you repeat that?
The documentation when he bought the gun, the receipt, as well as the instruction manual, did any of those documents refer to it as a replica?
Well, no, but that's not positive. In fact, the purchase documents, which would be exhibits B, C, and et cetera, in the appendix, compose sales receipts and et cetera. But they were purchased from a well-known large sporting goods store, Dick's, And no paperwork, and they were purchased directly by Mr. Rhodes. No paperwork needed to be filled out. That would normally have to be filled out for any citizen, by federal requirements as well as state, for any citizen to purchase what we would consider to be an actual firearm, such as a handgun, a rifle.
Counsel, what is the definition of firearm under this statute?
Under Chapter 724.
How should we define it in the context of Chapter 724?
Okay. Well, under the context of Chapter 724, Mr. Justice, there's no statutory definition within the chapter of firearm. In the case law, it's usually defined under the common law method of, in general, that a firearm is a gun that can, by use of explosive force, can, or at least be capable of propelling a projectile by the use of explosive force.
So
And that's what we have here, right? This weapon killed a deer, correct?
Correct.
And would you agree that under the common law definition, this is a firearm?
Under the broad general category, common law definition, it is. But the chapter itself, in an immediate preceding substatute to Section 26, which is the felony possession statute, is Section 25. And it gives a specific definition to the term antique firearm and replica. And generally speaking, when we have a specific definition of a term, that specific definition controls.
But counsel, isn't that statutory definition in connection with offensive weapon? It's in a different statute than the firearm section, and the felon in possession criminalizes possession of a firearm or offensive weapon. So you've persuaded me he didn't have an offensive weapon under that definition, but it still leaves firearm. How do we get around that?
Well, the definition of antique firearm and replica appear in two places in this code, in this chapter. One, as you point out, the first place it appears, Mr. Justice Waterman, would be in subsection 1 of the statute dealing with offensive weapons. The second place it appears would be in subsection 25 of the statute, immediately before subsection 26, the felony possession. And moreover than that, subsection...
Counsel. So that definition says for purposes of the chapter, right?
Correct.
So what other places, what other provisions of chapter 724 does that definition appear? Does that antique firearm appear?
Outside of subsection 1, the offensive weapon.
Right.
Right. You won't find it. You won't find it in subsection 26, for example, but that tells us something.
Well, so to follow up then, historically though, 724.15 that deals with permits used to use that term, and then when the legislature changed to remove the permits, it no longer uses that. But as I understand it, that subsection used to exclude, made an exception for pistols or revolvers that were antique firearms.
But that's my understanding as well. But
So if antique firearms is used as an exception for pistols and revolvers in that subsection, which obviously is no longer in effect, how does that affect your argument?
I don't think it affects it at all, because we've got to read subsection 25. It has, subsection 25 itself has two subsections. And the first subsection defines the term felony, which is clearly directly related to the subsection 26, the felony possession statute. The next section then goes to, as used in this chapter, defining an antique firearm and a replica. And it's different than defining the term firearm. because the definition of a replica of an antique firearm doesn't track the definition. It's a more particular definition than simply the term firearm. And to help the analysis, we do know from the corresponding federal act, the federal firearm statute, which also criminalizes a felon being in possession of a firearm, that under the federal act, using exact language of defining an antique firearm and a replica, that those guns aren't covered by the unlawful possession in the federal act.
Counsel, let me ask a question about that. I'm looking at Exhibit N. I believe that was one of the exhibits that you had. It was from the ATF advice about what's included under the federal statute.
Yes, sir.
And this is where, for example, you were pointing out that under the federal statute, the Thompson Center Encore contender is identified right as not being a firearm. And that's one of the points you make in your case. But doesn't the federal advice from ATF make it clear that under state law, firearm might be defined differently, and that you should contact your Attorney General's office to inquire about whether a firearm, the definition of firearm for state law includes a black powder weapon?
I agree that the federal act is not express preemption, field preemption, implied preemption for the state law act. And the states handle this matter differently, even though states like Iowa that track the federal law language. I can give you an example. Take the Sunshine State, the state of Florida. It too follows the federal act concerning replica of antique firearms, and does not, and by that token, does not prevent a felon from owning such a replica of an antique firearm. But it puts a twist on it. It says, however, under Florida's felon in possession statute, it has an exception. If the replica of the antique firearm is actually used in an act of criminality, that criminal can be convicted for it. So, yeah, states have flexibility in this. They're not.
In your view, what is the purpose of this statute? Of the felon in possession statute?
Well, the purpose of the felon in possession statute, the purpose is to keep dangerous weapons out of the hands of criminals.
So, if that's the purpose of the statute, and the statute uses the word firearm, and your client possessed a firearm that was capable of bringing down a deer, doesn't that seem to be within the scope of the statute, that it's a dangerous weapon?
But it would have the same purpose, Your Honor, or Mr. Justice, would have the same purpose under the federal statute. The federal statute, for the purpose of the corresponding felon in possession, prohibiting the felon to be in possession of a firearm, is the same. These replicas of antique firearms, why they can cause harm, really aren't as useful for criminal purposes, such as a handgun or a rifle that fires fixed ammunition, or under those. It is a policy judgment, but by the same token, well, I guess that's my answer. And it's historically been that way under the federal act. So it's not something that's just happened recently, and the federal people have not changed it. The federal government, the legislature, has not changed that since they had this exception.
So, what do you do with our old case law that does define the word firearm for the purposes of this statute under the common law method? To rule in favor of your client, do we need to overrule those cases?
No. What we need to do is apply the immediately preceding subsection, subsection 25, is specifically geared, particularly its first subpart, to subsection 26. What I'm saying is, we shouldn't put, lawyers and judges should not put a defined term of a statute in one subsection of the statute into another. What we're really trying to do here, and I think what the problem, the flaw is, on the felony is, why define immediately prior to the felony possession act? We know the federal law history. Why define replica of an antique firearm immediately before the felon in possession statute, and then not include the replica of an antique firearm in that statute if we wanted to criminalize that activity? The fact that it is not included there tells us it's not supposed to be in there. And really,
Are you talking about the offensive weapon definition?
no, I'm talking about the terms offensive weapon and firearm that appear in subsection 26, the felon in possession statute. Nowhere in the statute do we see the terms antique firearm or replica that appear immediately before that statute. We do see it in the offensive weapons statute, but it's not. It should have been included in the subsection 26 if it was the legislator's intent to so put it in there.
So is it your position that an antique firearm is just something different from a firearm? You have dangerous weapons, or the offensive weapons, you have firearms, and you have antique firearms, and those are three very different things?
Yes, it is my position that an antique firearm that's replica is different because it's separately defined. I mean, there's no question it is separately defined. We can see that in the immediately preceding subsection of the statute from the felon in possession statute. And the immediately preceding subsection 25, poignantly defines the term felony expressly for purposes of defining the felon for purposes of subsection 26.
Okay, thank you. Well, you get to come back. Your light is red.
Thank you.
That's okay. Thank you. Mr. Howe, state.
Thank you, Your Honor. May it please the court. Counsel. We judge the legislature's language by what they said, not what they should have said, not what we think they might have meant, but what the words they selected are. Since the adoption of Iowa's new criminal code in the 1970s, this court has given the term firearm a straightforward, common-sense dictionary definition of an implement capable of expelling a projectile by explosive force. It's a definition that makes sense, and it's a definition that includes the firearm that Mr. Rhodes
Mr. Howell,
used to kill a deer. Yes, sir.
let me ask you a question about whether what the legislature said, according to you, makes any practical sense. I mean, what is the point of excluding replica firearms from the definition of offensive weapon, but not from the definition of firearms? I mean, what practical difference or purpose does that serve?
Absolutely, Justice Mansfield. The practical implication is actually very common sense. No one in the state, barring certain occupations, can have an offensive weapon. So it is sensible for the legislature to say ordinary citizens cannot have these offensive weapons except for these implements which don't meet that definition. However, felons, people we are presumptively concerned about because of their inherent dangerousness, can have
take this replica firearm here. What practical reason is there to exclude it from the definition of offensive weapon if it's a firearm anyway?
Sure. As this court said in Pinckney, offensive weapons and firearms are terms that are distinct. And we can see from the structure of Chapter 724 that no one, except for those certain occupations, can have an offensive weapon, including ones that have a historical value. So, for example,
but this wouldn't be an offensive weapon anyway.
I agree with you, Your Honor, but it is a firearm, and it discharges a
But then why do you need to exclude it from the definition of offensive weapon? That's what I don't understand.
I'm afraid we're at a little bit of a loggerheads. I'm trying to articulate that offensive weapons are a class of weapons above and beyond what an ordinary firearm are. They are so dangerous so presumptively a risk to the community's safety, that ordinary citizens, even law-abiding ones, cannot have them.
Like a machine gun.
Exactly correct. Or a ballistic knife is an odd
But you don't have a muzzle-loading machine gun. I mean, that's, it doesn't make sense. That's what I'm driving at. Why? I mean, I think you have a good point on how the statute's read, but it seems, reading this language that seems borrowed from the federal statute as not incorporating the federal exclusion doesn't seem to serve a practical purpose here.
Sure. Give me a moment and I'll try to address your concern.
Sure.
I'd like to address basically three general temporal ideas in the course of this argument. The past is prologue for our current state. The present in terms of what the legislature has done since this court's rulings in the 1970s and 1980s, and the implications of what this interpretation that Mr. Rhodes is advancing would do to Iowa law. You're correct that in 1968, the federal government adopted a gun control statute and included an antique firearm exception. Our legislature, when it revised the criminal code, declined to include that definition as an exception from the term firearm. It left firearm undefined. Commentators at the time said that this wasn't necessarily remarkable. There was already a common law definition of the term that had served relatively well, and it's the one that remains in place today, a device that expels a projectile by explosive force. And since that development, since the adoption of the new criminal code, there has been no adoption of the definition firearm within Chapter 724. I would submit that coming to the present, when the legislature did for the first time define firearm in 2021, it demonstrated the correctness of this court's 1970s and 1980s pronouncements when they adopted almost verbatim the exact same definition for purposes of Chapter 683. I'll be the first one to admit it. That chapter deals with suing firearms manufacturers and includes the precautionary language for purposes of this chapter. But what it demonstrates is that this court got it right in 1978 in Lahr in defining what a firearm is.
Counsel, I'm hung up on section 25.
Sure.
So section 25 has two parts to it. The first part defines felony. The second part, it defines antique firearm. The next section, section 26, is the felon statute. Why define antique firearm in section 25 sub 2? What is the point? What's the purpose?
Justice McDermott, Justice Oxley has actually already beaten me to the punch on this point, but she's correct and I'll reiterate it here. We need to look at the 1979 code, which was the first time the new criminal code came into effect. And in that instance, there were two references to the term antique firearm. And the second one wasn't inside 724.26. It was inside 724.15, which stated that in order to obtain a pistol or a revolver, you would have needed a permit, but not for antique firearms, ones that were non-serviceable. And so that is why it is there. It's basically a...
But counsel, I'm looking at the updated code.
Yes.
So I have to give effect to all portions of this code. And so how do I give effect to this subsection now, considering that it's still there?
Absolutely, Your Honor. Canons of statutory interpretation sometimes butt up against each other. And what you're pointing to right now is this idea that we can't have surplusage in the code. That wouldn't make sense. And the answer is that this portion in 724.25 sub 2 is a little bit of a vestigial leftover of the earlier version of the code, but we can remedy that quite easily with the other statutory canon of just treating it as belt and suspenders. It's the same definition in 724.1 exception for offensive weapons. That's the exact same treatment we should give it now, if we absolutely must.
So are you agreeing that it really serves no purpose in sub 25?
I don't want to say it serves absolutely no purpose, but I think historical context informs what it is, which is that it's a leftover from an earlier time, but it's still useful. It basically is the legislature saying, once again, this antique firearm is not an offensive weapon. But again, even if we were concerned about how it impacts, it also uses different language than the definition of felony. 724.26.1 directs us to say, 25.1 says, for purposes of section 26, this is what a felony is. And then it omits any reference to antique firearm. Again, as this court has said in the past, in Pinckney, that means that we are not reading in an exception to the word firearm that doesn't exist. No such exception has been stated within the 4 years after that announcement was made. And so I think the clear answer here is that whether or not this firearm is a replica, whether or not it's antique, it is a firearm. It discharges a projectile and it will kill.
Counsel, you cited some out-of-state cases, and the statutes, I believe, in those cases said any firearm. And I looked through our chapter, and there are a few places where it says firearm of any kind. Is firearm of any kind different than firearm?
No, Your Honor. I think it's, I understand, again, we wouldn't want to treat anything as surplusage, but again, given this court's definition within Chapter 724, I don't think any kind will modify it in a way that would cause us concern. And I would also say that in this instance, Justice McDonald, your question, yes, absolutely, adopting Mr. Rhodes' interpretation will require you to overturn 40 years of precedent in this area. And I would add that this is one of the instances in which stare decisis is at its strongest hold. This is an instance in which this court announced a definition of an undefined term, and the legislature has had more than 40 years, if it disagreed, to correct it. And we know it didn't disagree with this court because if you look at other sections within the code, they also use the unadorned term firearm. For example, trafficking a weapon, bringing a firearm onto a school ground, or reckless discharge of a firearm. Mr. Rhodes' interpretation would create a quite wide loophole for individuals who wish to use an implement like this.
And counsel, throughout that 40 years, under the felon in possession, we've used the common law definition. Was subsection 25 parked right next door that whole time?
Correct, Your Honor, the entirety of that period of time.
Could you give me I'm sorry to keep following up on this. Give me an example of something that would be an offensive weapon, but is an antique firearm and therefore is excluded from the definition of offensive weapon.
Certainly. I think a cannon would suffice. It is an instrument capable of propelling a projectile by explosive force of a very damaging nature. But if it is inoperable or if it is antique and it fires in a way that its ammunition is no longer available, it would fall outside the definition of an offensive weapon based on the exception.
Would another example be if you had a musket and you made the barrel less than 16 inches? Would that be another example?
I believe so, Justice May.
Counsel, if we think that this statute is ambiguous, we can't reconcile why Section 25 is right before Section 26 and why antique firearm is defined there, should we invoke the rule of lenity, which says that when there's reasonable doubt,
sure, I understand
we should interpret it in the defendant's favor?
Absolutely not. The reason is because the statute is not ambiguous. This court has said so in Sadiq in 1986. Its definition has remained unchanged. And when determining whether or not a statute is ambiguous, we look not only to what the legislature says about it, but if the term is undefined, this court can look to a dictionary, just as it did in 1978. There's nothing ambiguous about the term firearm. And there's certainly no cause to turn to the rule of lenity, because also, again, in determining whether or not something is ambiguous, this court will look to its own precedent, which has been in place, undisturbed for 40 years. There's no cause to find the statute ambiguous.
Counsel, let me ask you a little bit about the defendant's argument that there are significant policy differences between modern firearms and what he's dealing with. And he suggests that although it took down a deer, it doesn't use cartridges, it's not very dangerous by comparison to modern firearms. How would you respond?
I think that argument cuts quite deadly in both directions for him. Unfortunately, the legislature's purpose in creating 724-26 is to disarm felons, full stop. They are not to have firearms, whether or not they function, as we learned from Pinckney, and whether or not they're antique. I would also add that even if there were differing policy interpretations or questions, we would look to the language that the legislature used, and we wouldn't attempt to legislate on our own. And so, again, I think this court's definition has served the state of Iowa quite well for the last 40 years, and it should stay true to it now. Just to move through my outline just briefly, I do want to turn to the question of additional implications of what this interpretation would mean. The term firearm is used throughout the code and within Chapter 724. As I've already touched on, it would actually create a loophole in several already existing crimes. And I just want to touch on the idea, and I think Justice May, your question is getting at this, is what is the significance of the federal legislation on this topic? And the answer is none. Whether or not the federal government defines a firearm as having an exception that is an antique firearm means nothing for the state of Iowa. We are a separate sovereign, and we are capable of exercising our police powers, and the legislature has done so here. because this court got it right in 1978, and because the legislature believes that this court got it right in 1978, and because the interpretation advanced by Mr. Rhodes is one in contravention of that past precedent and would become quickly unworkable and introduce a number of headaches for police, the public, and the legislature alike. This court should reject his attempts to read an exception that the legislature has never created. It should affirm his convictions in the district court's denial of his motion to dismiss. Thank you.
Thank you. And back to you, Mr. DeVolder.
I'm going to start off with the state counsel's example of what an offensive weapon might be. And ironically enough, he used a single example, the term cannon. If you look at subsection 1 of chapter 724, which defines offensive weapons, cannons are excluded from being an offensive weapon. In the very same sentence, that's subsection 1, paragraph C, on the very same sentence on which muzzle loaders, rifles, revolvers are excluded from being an offensive weapon. And that's kind of important when we look at the statute, because it does not make sense for an antique weapon to only apply to an offensive weapon, which the state's counsel says are the worst, most dangerous types of weapons, even more dangerous, of course, than these small rifles, muzzle loaders, and handguns that we're discussing concerning that. Why would only an offensive weapon, the worst kind of weapons, such as the machine guns or whatever, be the only one to have an exception for an antique weapon or its weapon?
I want to go back to firearm. You say antique firearm. I think everyone agrees it's a replica. So wouldn't a huge gaping hole in it, if we interpret the statute as you say? I'm a former trial judge. I have a lot of experience with people who get a felony, and I understand what I believe the legislature wanted to do with felon in possession. Wouldn't it just be incredibly smart for Shields or whoever else out there start making stuff, call it a replica of an antique? And if you can take down a deer, I don't care what you're calling it. Isn't that a firearm? And a replica of an antique has got to be different. Isn't that a huge hole that we're opening up?
No, I mean, that would be like labeling this microphone as a Rhodes. And what is it?
That's kind of what you've done. None of the paperwork that your client had said it was actually an antique or a replica. None of it said that. You're just calling it that, aren't you?
No, because the definition of an antique firearm and its replica is by statute. If a big box manufacturer who sold muzzle loaders or rifles tries to go around that definition simply by the box to say here's an antique replica of a firearm and it doesn't fit the statutory definition, it's not going to work.
But if it fits the statutory definition, it sure would, according to your argument.
I'm sorry?
If it fits the statutory definition, if they check all those boxes as a replica and say that it's for using conventional rimfire or centerfire fixed ammunition, lots of words, but it could check all those boxes and it would qualify according to your argument, right?
Yeah, as long as it otherwise qualifies as an antique. It has to be an antique weapon, which would have been of a vintage before 1898. And on a replica, of course, it can be manufactured after 1898, but in addition to finding those characteristics of a typical antique weapon, it has to fit those other characteristics defined in the statute, which you're correct, one of which would be that it can't fire fixed ammunition.
Counsel, I have a question about the statute. As Mr. Howe noted, Section 25, when it's talking about a felony, starts with, as used in Section 724.26, specifying the felon statute. In Section 2, when it's talking about antique firearm, it starts as used in this chapter. What are we supposed to read from that distinction?
Well, the distinction obviously is the term felon, which basically defines a felon for purposes of subsection 26. It's targeted only to that application. The second paragraph is not limited to simply subsection 26, but it is inclusive of subsection 26, because subsection 26 appears in the chapter. It's broader. This definition would apply, is used anywhere in the chapter. Did that answer your question?
It did, although your argument, I think, is that we need to specifically put antique firearm, reading that into section 26.
Yeah,
It's curious, I think, that felony is specified as to applying to section 26, but antique firearm is not.
correct. What needed to be done was in subsection 26, just as the term felon for felony appears specifically in subsection 26, to criminalize the possession of an antique firearm in the state. If the legislature intended to do so, it needed to stick to the defined term, antique firearm, right in the next subsection of statute 26, which the legislature did not do so. What the state is asking us to do is stick that term into 26. And this is going to overturn no precedent, because there's never been a case where an Iowa citizen or resident has been found guilty of the felon in possession statute in possession of an antique firearm. In fact, stores and manufacturers don't treat antique firearms the same for sale purposes.
Counsel, you mentioned earlier that that Mr. Rhodes did not have to register this when he bought it. What code provision do you know governs registering firearms now? Do you know?
Pardon?
What code provision governs registering firearms?
State or federal?
I know, but do you happen to know the specific Iowa code section?
I don't know what Iowa code off the top of my head. The federal statute is listed in Exhibit N, but off the top of my head, I can't remember the specific state statute.
Thank you.
But you'd agree that Mr. Rhodes didn't violate any laws, state or federal, by purchasing this without going through the background check, correct?
Correct. I mean, and if you look at the testimony of the expert too, the expert says, who's an expert gun dealer, they said, I don't know if you're a fan of the show Pawn Stars or not, but for example, they only buy antique firearms, that is guns manufactured before 1898, because you don't need a license or anything to do that, and that's why.
Okay, thank you. Did the court finish your questions? Thank you, sir. The case of State versus Rhodes is hereby submitted.